And good morning, and may it please the court, Your Honor. My name is Donald Schutz. I represent Appellant Eric Manuelan, who is within me in court this morning. The trial court erroneously held in this case, in paragraph 42, that any interest of Appellant Manuelan in this stock, such interest would have been extinguished by Laura Kirkland's actions in naming Jennifer Starr as the sole beneficiary of the Laura Kirkland's trust, and by transferring the KRLE shares to the Laura Kirkland Trust. Because that ruling is patently erroneous, it contravenes Florida's UCC and common law principles, providing that transfers to bona fide purchasers only extinguished unrecorded claims, and also violating section 678.03. I'm sorry.
So it's patently erroneous because who was not a bona fide purchaser?
There's no authority for it, Judge. You're correct. Only transfers to bona fide purchasers distinguish claims, both stock, certificated securities, and common law. But in this case, the court, the South Carolina court.
I think there's maybe you can disagree with this is one step back or one step forward in the process of analysis, but taking one step back, doesn't your entire theory, both as to the, don't you have to buy your actual theory, the merits of your theory, to get around the problem with having not presented this probate court?
No, Your Honor.
And because all those arguments have kind of rely on your theory that this marital settlement agreement was actually a vested property right and was self-executing.
Correct.
That's how you get around the idea that you know, it's not against the decedent because, well, she expired and therefore the decedent's out, so it's not a claim against the decedent.
Correct. Two separate minor.
So you have to buy that theory. You have to buy that theory to get around the probate problem.
No. My client never had a claim against his mother in probate. There was no pre-death claim here.
To get there, you have to rely on the fact that this dissolution decree, the incorporating our settlement agreement, was self-executing. And therefore, upon the decedent's death, the claim is not against the decedent.
I would say
because
that
immediately,
I'm sorry.
she was immediately divested of any property interest.
That's one.
So you have to do that, or else this is a probate matter.
It is not, Your Honor. It is not, because it was never property of the probate estate, and it was never a claim against the individual. Under 733-702, the claim statute, I only have to file a probate claim if I'm seeking property of the probate estate. This was never property of the probate estate. It was transferred to a trust.
Wait a minute, aren't you the argument both sides of the mouth in there?
No, Your Honor. It's two.
Well,
if it was,
I'm asking whether your theory, whether we have to buy your theory that at the time of her death, you know, you're saying that. I thought your theory relied on the fact that, you know, that this trust is a nullity essentially, because it's a derogation of the superior right that your client had under the marital settlement agreement.
Correct.
Now you're relying on that to say that this is outside probate when I was making the point that you have to buy your theory to get it out that this actually was property of the decedent all the way up until she deceased, even though she did not subject to trust, but not, and then it suddenly becomes not property of the decedent. So it's not a probate issue. But then to get it back into play, you know, to get it, then you have to get it out of probate by saying, oh no, there was a trust. But you're saying the trust is a nullity because of the marital settlement agreement.
not quite, Judge. First of all, full faith and credit does require us to honor the text. The text says, shall be divided upon her death. That's what it says. Doesn't say she's supposed to take anything. That's why they've gone to great pains to claim, well, this was really a contract to make a will. It's not a contract to make a will. Laura Kirkland had no obligations after that order was entered whatsoever with regard to these shares. And so we have to honor the text, even if it's wrong. The Florida Supreme Court and the United States Supreme Court have both said that if a trial court enters an order that's wrong, we still have to honor that. They have to appeal it. They didn't. They have to try to move to vacate it. They did not. If Laura Kirkland did not want to comply with this court order, she had to appeal or go to South Carolina, the South Carolina court order.
The marital settlement agreement?
The marital, well, it's a court order, Judge.
Yeah, the dissolution.
It's a final judgment, and it in
So
the
now it has to do with whether her partner, her subsequent partner, how she appeal?
it's a court order, and I agree, this is a very important distinction. When the trial court looked at it, I agree that it seems that the trial court looked at it more as a contract than a marital settlement agreement. This is a court order.
Presuming it's a court order, how is the subsequent partner of the now decedent supposed to go back and to have appealed that dissolution?
No, I'm saying Laura Kirkland, before she died, Laura Kirkland in 2009 transferred.
The party to the dissolution.
Laura Kirkland, before she died, could have.
Okay, so you're saying she's bound?
She's bound.
Okay, she's bound.
And we're
Let me
bound.
ask you another question then, because you're arguing the trust on one, the trust, transfer the trust on one end, and the fact that she's, deceased, she no longer owns the property. Let's say, yes, it's a trust asset. Who's the settler of the trust?
The settlor of the trust was Laura Kirkland.
Yeah, and she's deceased, right?
She's deceased.
Doesn't that mean that you have to make a claim in probate?
No, 736-1014 is the trust.
Settler died.
statute. Settler died, and the claim is only if it's premised on the individual liability of the settlor. That's direct language from 736-1014. This claim of Manuelan's is not contingent on the individual.
That's
because it's a court order that states in it that it is to be distributed upon death, and she does not have any.
So it's the settlor, the probate code doesn't apply because it's not a claim against the settlor. Again, it goes all the way back again to this theory that this is self-executing, right? It just relies on the theory, because you said, well, you concede that if it's a settlor died, you gotta make a claim in probate.
No, not at all. No,
If it's a claim against the settler,
If
we'll
it's
concede that.
a claim on
The reason why it's not a claim against the settlor is because she no longer owned the property at death, because she was automatically divested of the property right by operation of the marital settlement agreement?
No. 736-1014, the trust statute that tells us when we have to file a claim in probate court against trustees, says we only have to file claims if the claim is dependent upon the individual liability of the settlor. This claim is not dependent upon the individual liability of the settlor. This claim.
Let me interrupt for a second. Isn't this in the nature of a breach of contract?
No, Your Honor.
You're saying she's bound by the court order and it's automatically fulfilling. So it transferred the property to your client who is not a party to the underlying litigation.
Correct. This is not a contract. Once
So
it gets.
if she defies the court order and she hadn't passed away, she'd be in contempt of court.
No, she wouldn't, because she wasn't in contempt of court because she didn't have any responsibility until she died. She didn't have to do
But
anything.
if let's say she has all this money, has the money, and she puts it in trust and she's living on the income and depletes it all before she dies. Do we still have an action?
You would not have a pre-death action.
Because of what? What's your rationale for that?
Because the Supreme Court, our Supreme Court, in Briggs versus Fitzpatrick, 79 Southern 2nd, 848, specifically held that there is no pre-death cause of action for claims that take effect only on death. There is no cause of action.
She transfers the assets in her lifetime to a trust, but doesn't use them all up. Then you have a cause of action on her death because it's supposed to be transferred to your client?
No, Your Honor. The cause of action is that the transfer to the trust, number one, I agree that the transfer to the trust is upon the death is self-executing when we honor the text of the foreign order. We cannot modify the text of the foreign order. It's self-executing. If Your Honor doesn't buy that, if Your Honor says, we don't buy that, then what? Then it became part of the trust subject to the adverse interest in the court order that is not discharged or
The claim then would
extinguished.
not be against the settler, but Judge Valenti said, you know, why isn't the claim against the settler?
Because-
He's violated the dissolution agreement, and he's what, a third-party beneficiary of the dissolution agreement, and he's claiming against her for not doing what the dissolution agreement says, which is, hey, you've got to transfer these to the, you know, to your children at death, so therefore you violate the settlement agreement by putting it in a trust, with the beneficiary being your partner.
The court order does not say you must transfer these at death.
No, yes, it does. It says shall be transferred. By whom? Who else is going to transfer it?
Well, the person that transfers is the transfer agent of a corporation.
What's that?
Transfer agent of the corporation. That's why I sued the corporations also. The transfer agents of corporations.
Was the corporation a party to the dissolution agreement? The dissolution, the action in North Carolina?
No.
No, the wife in the dissolution agreement.
Correct.
And she's the one who's bound by the Member Settlement Agreement incorporated into the dissolution.
Her, in this case, yes, and the transferee, any transferee takes subject to an adverse interest. So if Your Honor, it doesn't buy my contention that it is a pay on death, we have to treat it as a pay on death, then when Laura Kirkland transferred it to herself as trustee, Laura Kirkland took that with notice, without value, and therefore subject to that court order. So there isn't a way that a person, a disgruntled divorce litigant, can say, I don't want to comply with this court order. I'm not going to take the effort to go to South Carolina and ask the court to modify it. I'm just going to give it to myself into a revocable trust. And by doing that, I'm free of the court order. There's no authority for that. They cite none. There is no authority. The authority is that any transfer to anyone other than a bona fide purchaser takes subject to the claim. And I've cited Demosthenes, I've cited many cases that say this.
So she, as trustee of the trust, owned the trust asset is a trust asset subject to the superior
Correct.
Right of the beneficiaries of the Member Settlement Agreement.
Correct, because she is not a bona fide purchaser.
Okay, so how is your client supposed to vindicate that?
What I did, I sued the trustee. The only way you can do it is to sue the trustee and say, look.
And that's not an action that's barred by the probate rules that require you to bring in probate.
Absolutely not. 736-1014, we look at it, doesn't allow the trustee to keep assets that the trustee does not have title to. It has nothing to do with title. This is a title issue, an in rem issue of property. It is not an adjudication of a personal claim. We never had a claim against the general assets of the probate estate. There's no claim here that Eric Manuelan could have gone into probate and said, she did something with this trust, so I want an equivalent amount of money out of the probate estate. That's not what this is, because transferring it to the revocable trust did not extinguish his claim as a matter of law under settled law. They don't raise any authority to the contrary. They just say, well, it was correct. And it was brief. They don't have any authority because there is none. And as a result of that, if you, again, don't buy my pay on death, which I contend, frankly, that it's a pay on death provision. It says is to be divided upon her death. There's nothing that she could have done to do that, because the right to do that only takes effect when she's gone. So it's.
You're referring to the clause in the divorce agreement.
I'm sorry, Your Honor, I can't quite hear you.
You're referring to the clause in the divorce agreement.
The divorce agreement, correct, is to be divided upon her death. And it's just like any pay on death provision.
The counsel is saying that her rights in that stock was vested before death.
Rights,
They went into the trust before her death.
and I sincerely apologize, Your Honor, I'm just not hearing you.
But the assets that were involved went into a trust before she died.
Correct. A revocable trust.
Revocable trust.
And because they went into a revocable trust, that revocable trust and the trustee took subject to the 1997 order because the trust did not pay value and had notice. That is, an individual can never improve title. And this case is, the court's opinion is.
While you're doing that, you're referring to the trust was not a BFP in your view.
Correct.
If they were a BFP, you would say you didn't have a case. Is that true?
Yeah, it's absolutely. If she would have sold it to her sister for $1 million and her sister did not know about this, then the sister would be a BFP, and that was a claim that would have to be filed in probate.
At your 5-minute mark, you didn't ask for time. Did you want 5 minutes for your vote?
I would like at least, let me have 3 if I
You
can.
keep going, but
I'd like
whatever
3.
You got when you're done.
3. So what I want to focus on is our right to both summary judgment and a constructive trust over the 100 shares. This Gale versus Harvey case was a case where a non-bona fide purchaser, where transfer was to property, and the Supreme Court held that the true owner can always reclaim property. A true owner of property can always reclaim property. We do not have adverse possession of personal property in Florida. So title is different than in personam jurisdiction for damages. I'm trying to reclaim title, and the title I'm trying to reclaim is that title vested by that 1997 order that then became Eric Manuelan upon her death, or alternatively, is still in the trust subject to this 1997 order. Now, the courts I know familiar with the concept of splitting legal and equitable title in the cases of real estate. We don't really have any personal property cases on that. But in this particular case, and there's several cases I've cited, Demosthenes versus Gerard is one, 95 Southern 2nd, 1189. In that case, two people owned real property. There was a corrective deed issued and left off one of the grantees. The other grantee sold it, and the court imposed a constructive trust on the proceeds, exactly as it was here. And that's the reason I'm pointing that out is, in this particular case, the stock went from was Kirkland Ranch Inc. stock, and it went into a company called RLE Ranch through a corporate reorganization. And so those cases are what I rely on to be able to trace those proceeds through and say that the trust now, because it wasn't a bona fide purchaser and took subject to the original 1997 interest. And this court also held in the general General Capital Corporation case, the statute of limitation only apply to actions of law. And in this particular case, I did file this action within the 12-year statute of repose. But in terms of my count 1, my declaratory judgment count, there is no legal theory that says that 42 is correct. You can look through the law. I'm sure they did. They never cited any cases that said that. And more importantly, Judge, I'd like to point out, it's not in their motion. This was purely a sua sponte ruling by the court. The court came up with this ruling that the transfer extinguished my client's interest. It's not in the motion, and just on that basis, reversal is required.
Inherent in the whole case.
Say it again, Your Honor?
It doesn't seem that novel. I mean, isn't that started? You can reserve time, but I'd say, isn't that, does that need to be stated? I mean, the whole point is.
It certainly needs to be stated. It's an incorrect legal theory. 678.3021 and 6.
Okay, but to say that it was somehow waived because it wasn't overtly stated, I mean, the whole.
Oh, the case law is very clear, Judge. The summary judgment cannot be granted.
I'll let you go on.
Very well.
Down to a minute, so you want to say any rebuttal?
If I may reserve, thank you, Your Honor. How many minutes do I have here?
A minute and 10 seconds.
Minute and 10 seconds. Thank you, Your Honor.
Good morning, Your Honor. May it please the court. We're ready. I want to just jump right in. John Schifino for the appellee, Mustar, who's here with me today. So I had my outline. I was going to start going through my outline and talking, but I wanted to highlight a couple of things. Judge Valenti, your question on the breach of contract, that is exactly what Judge Altenburn, that was the analysis in the Tense Flat case. That's exactly what he followed. And if we wanted to look at how this should have proceeded, it was exactly that. And that dovetails to your questions, Judge Atkinson. That's exactly what happened again, not to keep pointing to Tense Flat, but that's what they did. They sued the estate, and the claim was against the estate, and it was filed timely, and that's a case where we see, and again, 736-1014, it does exactly what you say it does. These are claims against a trustee, assets in the trust. The appellant in the briefing tries to paint a picture that there's something nefarious about not including assets in a trust, in a probate, of course, that's why we have trust. So there was nothing nefarious there. I just wanted to make sure that your questions were answered. And again, on the contempt, Judge Valenti, Valenti, back to your point, the order, the divorce decree that the court entered, that's exactly what the judge said there, is you parties, you are directed to go do what you agreed to do. That's in the order. And the last line in this is, if you don't, you parties who agree to do this thing may be subject to contempt of court. That's exactly what happened. Mustar wasn't a party to that. The trust wasn't a party to that. KRI, the Kirkland Ranch, wasn't a party to that. So that's, to answer your query on the contempt, Your Honor, again, that's exactly what the South Carolina court directed the parties to do. So there is a lot going on here, Your Honors, but I don't believe it's a complicated case. If we look at where this came from, and I promise this isn't going to be a long history discussion, but the 200 shares that we're talking about, Laura Kirkland, she obtained those shares in 1977. They're subject to a 1961 agreement. And that agreement limited what the shareholders, what Laura Kirkland could do with it. And it said, you cannot transfer or convey these shares unless you first offer them to the corporation or the other shareholders. So that's how she held them. And so after she was divorced, she got her estate in order in 2005. She created her trust. And that was in March of 2005. She was the trustee. And in 2009, she amended the trust, and then Mustar became the sole beneficiary. Children were the contingent beneficiaries. But still, that 1961 agreement, that was still in place. You can't transfer your stock. You can't transfer your stock. 2008, that's the reorganization, the amendment that we were talking about. And that's the time when all of a sudden the shareholders get to do this. Laura Kirkland and all the KRI shareholders get to do what Laura Kirkland did. Take my stock, return it to KRI, the entity, and get it back where it says Laura Kirkland trustee. And that's what she did in 2009, the year after the amendment. And then she passes away. So the will, I wanted to just very briefly, in December of 2005, when Ms. Kirkland amended her trust, she designated Mustar personal representative. So Ms. Kirkland sadly passes away in 2009. Mustar does everything she's supposed to do. She opens the probate in 10, files the notice to creditors, files the notice of trust. The notice of trust says, hey, we're the trust, we're going to pay the administration expenses and any creditors' expenses. That's what the notice of trust does. And the probate closes. There's a consent to Mustar serving as the PR. Mustar does everything right. But what happens? How does Mustar end up with these RLE shares in the Jennifer Starr trustee for the Starr Trust? That's the 2011 reorganization. That's the divide that Appellant was just talking about, where we have KRI shares, you have RLE shares. And I mention this very briefly because it just brings us full circle to where we are. All of the shareholders, KRI, and at that time, Appellant's a shareholder of KRI, so he participates in this transaction entirely. I think he got his shares in December of 2009. This reorganization is, we're going to surrender our shares and we're going to get new shares. And they did. All the shareholders got new, either KRI shares or like Mustar and like Appellant, these RLE shares. And the shares came back to the appellee, Mustar, as trustee of the Starr Trust. And they all consented to it, including the appellant. This was all okay. Nobody's claiming that we did anything wrong up to this point.
Okay, so let's get to the
Yes, sir.
case.
I will. The UCC argument, first and foremost. Your Honors, please apply the UCC to this settler establishing a trust. The UCC's never been applied to a settler establishing a trust. It's not the way it works. The UCC applies to commercial transactions. It's in the name, Uniform Commercial Code. And so we invited the appellant, please show us a case where a settler has been scrutinized and his or her trust has been scrutinized under the UCC as whether or not we have a bona fide purchaser of the trust. They didn't find the case. And they couldn't find the case because it doesn't exist. They're inviting, Your Honors, this court, to be the first court to ever apply the UCC to a settler contributing his or her property to a trust. You'd be the first ones. It doesn't exist. So the UCC, it doesn't apply. And we hope that's a simple issue for the court. The argument that, Your Honors, this divorce decree, it automatically, and not to be cheeky, but magically vested appellant into this, an in rem beneficial interest, I think that is what it's been called, into the stock. It's not what the order says.
So if we disregard that rationale,
Yes, sir.
Appellant is saying he still gets around the requirement to bring his claim to probate because you heard his argument. Can you address the arguments?
Oh, absolutely. Yeah, of course, Your Honor. So just first, a little bit of context about the arguments. I mean, I get it. My mom didn't leave me anything. She left it to somebody else. I'm mad. And I didn't know about this because I was estranged from my father until 2020 or 21. So I'm late. I'm 12 years late. What do I do? How do I get around the 2 years of 733, 710? Well, if I look at 736, 1014, any claim, and you asked the right question, doesn't this involve the settler, the decedent? Any claim involving the decedent, anything the decedent did, and this isn't a before issue, that's 733, 702. Any claim involving decedent has to go to probate court. That's what 1014 says. So what's the argument here? I mean, I get the argument. Well, my mom didn't do anything wrong. She's the bad guy because she won't give me my stuff. I've asked her for it, and so I'm going to sue you, other beneficiary, for conversion. I'll sue you for replevin, and I'll sue you for fraud. Even though you did everything Laura Kirkland asked you to do, asked her to do, she did it. And now she's getting sued for fraud. So even though Laura Kirkland's the person who established this trust, and this is a trust that Ms. Starr was the successor beneficiary and trustee upon, and she became the trustee upon death. She was the sole beneficiary. Even though Ms. Kirkland did that, even though Ms. Kirkland's will was a pour over will, all of her assets into the trust, and even Ms. Kirkland, who established this trust, which became irrevocable upon her death, and even though Ms. Kirkland didn't take a single act after 1997, not a single act, to make sure that she complied with what she agreed to do. She did everything other than what she agreed to do. Even though she did all those things.
The appellant is saying that it's not a claim against the settler's estate under 736.1014.
Sure, I understand your.
736.1014 directs the claim to file the claim against the settler's estate. So I guess can you address that? I mean, that's the argument that we were discussing with the appellant about.
Sure.
Again, getting around the requirement to bring in the progress.
So what I would suggest to your honors collectively is this is a roadmap. This is how chapter 733 dies. It does. If your honors buy this argument, you've killed 733, 710, and 733 and 702. Because if I'm the beneficiary who's missed my 2-year deadline, and even though the settler did all of these things, it doesn't matter. I don't care, because I can sue this other beneficiary 10 years later, 20 years later, 30 years later, for what my mom did. Now, she left her the stuff, and that makes me mad. So she did all these things, Your Honor. The deceit, it fits right within 1014.
Because it's the individual liability of the settler?
Yes, Your Honor. Absolutely. Ms. Starr didn't do anything wrong. By the way, Ms. Kirkland didn't do anything wrong. I'm not suggesting she did anything wrong. She decided she didn't want to do this. She didn't want to leave her stock. She was very deliberate in her efforts not to do this. She knew exactly where she wanted to go. So I'm not even suggesting she did anything wrong. But we know Ms. Starr didn't do anything wrong. She did what Ms. Kirkland asked her to do. So to buy this argument again, it's the end of 733, 710, and 702. Because I don't need it. I don't need it. It doesn't involve the settler anymore, even though I don't like what the settler did. I can go after the beneficiary anytime. For the rest of her life, I can chase her. 30 years later, I was estranged from my dad. I didn't know. Now I know. So I hope that answers your question, Judge Atkinson. I understand. But again, this is a roadmap for every disgruntled heir. It really is. All I got to do is say it's not the settler's fault, even though I don't like what she did with the money. I can go after the beneficiary.
And then subsection 2 says this section does not include a direct action against the trust. The trustee of the trust or beneficiary does not depend on the individual liability of the settler. So you're saying this is squarely the individual liability of the settler.
Oh, absolutely. And in the cases we cite to the court, there's a rich body of case law of trustees misbehaving. And indeed, the cases that the appellant cites saying, look, bona fide purchaser's been applied to the trust. And again, these are never to a settler establishing a trust.
She was the trustee at first, wasn't she? She was her own trustee.
She was, yes, Your Honor. And then, and Ms. Starr was the successor trustee.
So that doesn't count because she wasn't at the time of death trustee.
So Ms. Kirkland was not the trustee. At the time of her death, up to the moment she died, yes, she was a trustee. And then Ms. Starr became the successor trustee.
Okay.
So, Your Honors, sorry, I'm scattered here all over the place. I just wanted to make sure that your answers were addressed. I think you understand. We've briefed the issues. If you have any other questions, I'm more than happy to answer those.
So why don't we talk about the other, perhaps the main trust, which is that this, well, perhaps it's not the main, perhaps it's an alternative trust, which is that, or it's just a parry of a different blow, which is that this is not the decedent because the decedent no longer, it's not a claim, it's not an ask of the decedent, or it's not prohibited by the requirement to bring a claim regarding the decedent because she's out of the picture because it was self-executing, and at the time of her death, she had no claim to property automatically as a matter of operation of the settlement agreement.
See, that's what I get for asking for any more questions, but I invited it. So, and I just want to make sure I understand your question, Your Honor.
Well, I want you to tell me to understand. I want to understand their argument, your argument.
Oh, absolutely.
So go ahead. And if you don't understand my question, if I can detect whether you understand.
Yes.
Just keep on going.
If I give a hint of understanding. No, I mean, I do, I understand the thrust, the way it was briefed and the way it was presented is we have a beneficiary who's saying, or an heir, not a beneficiary, but an heir, saying that this divorce decree, which I just learned about, automatically vested me in an interest in these shares in 1997. And it manifested in 2009 when my mother died. And so now I'm trying to enforce my interest in those shares. And Tensflet, that's a case where this gets spelled out. This whole case is explained in Tensflet because that was.
Could you refer me that?
Oh, absolutely, Your Honor.
Go on.
Well, and the benefit of.
I just have to remind which one it is, but go ahead.
Oh, yeah. Thank you so much, Your Honor. It's a Judge Altenburn opinion, and that's what happens when it goes right, Judge. There was a divorce decree, same thing, divorce decree out of state, and much more detailed, by the way. That was a divorce decree where the parties, they spelled it all out. This is exactly what I'm going to do. And he didn't do it. He remarried, and he did another will, and he didn't comply. Interesting thing about that case, that divorce decree really expressly identified the children as third-party beneficiaries. So they sued for breach of contract as third-party beneficiaries, and they did it timely. And that's the procedure, that's the process, and that's who they sued. They didn't sue any new trustee or anybody that. They sued their dad because he didn't do what he said he was going to do. And they were third-party beneficiaries to that divorce decree, and that was their beef. Dad, you said you were going to do this and you didn't do it. And so they went after the estate. That's what should have happened here. So the result's a little bit different in Tensflet because they were timely. They did it right. One of the interesting things about Tensflet that you'll see is just like here, that divorce decree was never domesticated here. And Judge Altenburn wasn't very impressed with the effort to enforce that non-domesticated order. Same thing, divorce decree. Wasn't too impressed with that effort to enforce it here, and in fact affirmed the trial court's dismissal of those parties trying to enforce the order. And well, because it flows here, Your Honor, I don't think it's any different here. If the questions have been asked and hopefully answered, but that's how it should have been done. Again, enforcing that order against Mustar, who was never a party, enforcing that order against the Kirkland Ranch, who wasn't a party. Certainly, the court didn't even have jurisdiction of these parties. It just doesn't make any sense. So just like Judge Altenburn was dismissive of the effort to enforce that divorce decree, same thing, but a more clear divorce decree in Tensflet, we would hope this court would do the same.
Now, was there some similarities between the language of the directive and the divorce decree in Tensflet?
Not even close. They were much more, only.
Well, I mean, I presume your argument relies on there being some similarity, it being analogous, which is you're assuming based on the record here that, that I'm presuming that counsel for the appellant's going to get up and say, well, in this case, it said, shall be distributed to these beneficiaries upon death.
Well,
But in tense flood, they said what? I don't remember what the verbiage was in that case.
I've actually got it here. And the good news about tense flood, Your Honor, is that we both agree, in appellant's brief, the appellant says, yes, tense flood dictates the court's ruling here. Uses those words. We agree. We happen to agree. And the reason I say it's different, Your Honor, substantively, or at its core, it's the same. But for me to suggest that the language used there is like ours, it just wouldn't have been, it's not even close. Ours is pithy the right word? Ours is very brief and short. You shall divide among your children. The tense flood divorce decree is very particular about what the divorcing husband is supposed to put in his will. It's very, very careful. You shall execute, you shall keep, leaving not less than 2/3 to the children. It's on 722, Your Honor. So while the substance is the same, you have two divorced parents saying this is what you'll do. The tense flood, they're very particular about how it's going to go.
That particularity, it's not self-executing.
Oh, no, exactly right. Exactly right. They have to do things. You're a third-party beneficiary. You, children, you need to enforce this. That's right. That's exactly right. I'm cautiously going to invite any more questions. So I'm watching. But that's all I have, Your Honors. Thank you so much.
You've got a minute and 10 seconds. Start the clock.
Thank you. 1 minute. We have to honor the text of the order. It was an order, it's not a contract. It's a final order of the court. We have to honor the text of 736-1014. Kenstone, quote, shall execute and shall hereafter keep in effect a will leaving not less than 2/3 of his net estate to his children. Directed to write a will. That's why in their motion they say it was a contract to write a will. This isn't a contract to write a will. This is a text that we have to honor that says is to be divided upon her death. Nothing happens until she dies. And then it is to be divided upon her death. So my point is, in 736-1014, Your Honor, focus on exactly what I'm talking about. It says is dependent on the individual liability of the settlor. Those are the only claims that were barred from suing a trustee for. They have never articulated how this claim is articulated.
The settlor didn't do what the marital settlement agreement incorporated in the dissolution. He said,
Disagree.
required to do.
Disagree. Transferring to a revocable trust does not violate the order, should have right to transfer it. The trust code says a revocable trust, the person retains.
So not to be morbid, I apologize to all involved.
That's the end of your time.
She died prematurely before she undid what she did in violation of marital settlement agreement.
She did not violate.
She should have revoked it before she died, and then she would have been declared, and then it wouldn't be.
She,
And then it wouldn't be.
Mr. Schultz, I don't want to cut you off, but since you're out of time.
I understood your point you made.
All right.
And I didn't mean to give a call, but I know that.
Did you want me to answer or no?
I understood.
He understood.
Very good, Your Honor.
Thank you.
Thank you for the
Have a
time.
nice
Thank
day,
you for the
folks.
courtesies.
Thank you, Your Honor.
It's a long-term beach cottages.
Okay.